All right, good morning, everyone. It's Thursday, February 16th, 2023, and this is the regular meeting of the California Fair Political Practices Commission. Ms. Linker, would you please call the roll?
Commissioner Baker?
Here.
Commissioner Wilson?
Here.
Commissioner Wood?
Here.
Chair Matich?
Present. All right, we'll proceed to item number 1. That is public comment for items not on today's agenda. Do we have any public comment? Hearing and seeing none, we'll proceed to item 2. Approval of the January 2023 Commission hearing minutes. Do any commissioners have any edits or comments on the meeting minutes from January? Hearing and seeing none.
Move to approve.
So a motion to approve. I will second. Do we have any public comment on item 2? Hearing and seeing none. Ms. Linker, please call the roll.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood? Chair Matich?
Aye. Okay.
The motion passes.
Great. All right, we'll proceed to our consent calendar, and today that is 2 items, items 3 and 4. Do any commissioners wish to pull an item from the consent calendar for separate consideration?
I have a couple questions about item 3.
Item 3. All right. Let's go ahead and proceed then with item 4, the only item on our consent calendar. Are there any comments or questions on item 4? Commissioner Baker?
Oh, it's possible to make a comment without pulling it from consent because that's not my intent. It's just to underscore, as I understand it, that this was a subject of a different settlement, that the maximum fine, stipulation on a different side, a fine was paid elsewhere of a significant amount, and that we are charging them or stipulating to the maximum amount for one count, that would be taken into consideration should this ever be looked upon for a comparable. Because I understand that there are other counts that could have been part of this, but there was a stipulation with another agency that perhaps had influence on this. And I just would point that out for the record that we just watch this as something that would be a comparable because it does have some special circumstances. That's fair to say.
I think that's a good point. Good morning, Mr. Burton. Question for you, based on what Commissioner Baker was talking about. When we're looking at comparables, do staff look at the totality of circumstances within the comparable? So, for example, in this case, the charging came pursuant to a settlement agreement. So for purposes of a future case where there was not a settlement agreement, is that something that staff would look at when deciding whether it's appropriate in a later case that's not part of a settlement to look at this matter?
Yes, thank you for your question. We would. When we're looking at prior stipulations as comps, we really look at everything. And so, although in this case, we didn't charge it differently than we would have in any other case. I do think we could look at that just as an additional factor to compare and contrast.
All right, very good. Any other questions or comments on item 4, the only matter on our consent calendar today? Hearing and seeing none, I'll move approval of item 4. Is there a second?
I can second.
Is there any public comment on item 4? Hearing and seeing none. Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
All right, we'll proceed then to item 3. This is in the matter of Renteria for Governor 2018.
Yeah, my questions, I probably could have done the same thing Commissioner Baker did, actually. So there's some language on page 5 that confused me initially, and then I realized I probably read it the wrong way, so we might want to clarify. And it's about the spouse having the credit card. And so the way it leads in, it says, and her spouse was issued a card ending in the number. This meant that the credit card was not dedicated to the campaign and was an improper use of a credit card. And my immediate thought was, well, couldn't a spouse legitimately have a credit card for the campaign? Right? Isn't there's some situation where that must be the case, right?
Sure, that's a great question, Commissioner Wood. I think what made it a one bank account violation here was the actual use of that account that came later that they were using the account for both campaign expenditures, which might have been directly tied to Renteria's credit card, while tied to Brandley's credit card were personal expenditures. So it was the ultimate use of that account that rendered it a one bank account violation. So perhaps theoretically, yes, if they had limited both credit cards to campaign expenditures, then we would be looking at this differently.
Right. And I just wonder if we want to put that in writing for the public, if we want to kind of clarify there so that people would kind of have it straight. I don't know, maybe.
Sure, we can think about that going forward. Thank you.
And then the only other thing is, and this is something I've talked about before, on page 8 where we talk about public harm, the public harm isn't specified. And I was really struck by how well it was specified in item 4 in the Neal case, about how grave it was and how it goes to the public's perception of the government, acting in the public interest as opposed to having conflicts of interest. And here it just kind of, academics would say we hand wave it, right? So with respect to the first factor, the public harm stems from the failure to utilize a single designated campaign bank account, but it doesn't specify what that harm is. And I think it would be a really good practice in these steps to do that really as carefully as we did in Neal, because I think it helps people understand why we regulate these things. We really are trying to avoid public harm and not trying to just be a pain for candidates, So I wouldn't at all require either of these changes actually to vote for it, but I just wanted to bring these up because it was an example of a place where it really would be nice to see a more specific public harm listed.
Yeah, I think that's a good point, and the commission's made this point several times. I think this commission likes, I think, erring on the side of more information. And I think to Commissioner Wood's point, I think it's not always apparent to folks who aren't dealing with this every day what the precise public harm for a particular statute is. And so I think going forward, if we can get a little bit more detail in the stipulations, I think that'd be helpful for the reasons Commissioner Wood pointed out.
Absolutely. We'll do that going forward. Thank you.
Thank you. All right. Any more questions or comments on item 3? Hearing and seeing none, I will move to approve item 3. Do I have a second?
Second.
All right. Do we have any public comment on item 3?
Okay.
Is there public comment on item 3?
You're good. Okay, let me grab that.
Hearing and seeing none, Ms. Linker, please proceed to the vote.
Commissioner Baker,
Aye.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Match.
Aye.
The motion passes.
Very good. All right, we'll proceed to item 5. This is the first of our general items. This is our pre-notice discussion of the Levine Act regulations. And with us today is Assistant General Counsel Brian Lau. Good morning, Mr. Lau.
Start over. I'm here to present a regulatory package regarding the implementation of Senate Bill 1439 for pre-notice discussion. This package was necessitated by revisions to Section 84308, sometimes referred to as the Act's pay-to-pay restrictions, which took effect January 1st. Section 84308 has been part of the Act since the early 80s, prohibiting an officer from accepting, soliciting, or directing a contribution of more than $250 from a party or participant in a proceeding involving a license, permit, or entitlement while the proceeding is pending before the agency and for 3 months after the proceeding. The section also prohibits an officer from taking part in these proceedings if the officer willfully and knowingly received a contribution of $250 or more from the party or participant in the prior 12 months. However, this section did not previously apply to any decision before an agency whose members were directly elected by voters. Under this sweeping former exception, elected officials were not subject to the restrictions anytime the decision was before their own agency. And the restrictions only applied if the elected official also happened to serve on a separate appointed board or commission. Beginning January 1st, 2 significant changes were made to these provisions. First, the ban on accepting, soliciting, or directing a contribution following the completion of a proceeding has been extended from 3 months to 12 months. And second, the exemption for agencies directly elected by the voters has been removed. This is a very substantial amendment in that the restrictions are now applicable to elected officers making decisions as part of the agency to which the officer was elected. For the first time, the restrictions in Section 84308 will now apply to decisions made by elected officials such as city council members and county supervisors while acting in their elected position. Without question, this is a very substantial change to the provisions, which gets us to where we are today. Because of the importance of the provisions, staff is attempting a comprehensive examination and revision of all previous regulations interpreting Section 84308, and this is the regulatory package being presented today. I would emphasize that the current package is merely a draft, and staff is continuing to revise the package as we work with the regulated community and the Commission to examine the new provisions. It is staff's hope that publicly posting the draft language and the pre-notice being considered today will facilitate discussion with the regulated community, generate additional ideas, and help to identify potential concerns. Before going further, I just want to give an overview of the staff's review and outreach to the outreach related to the regulatory package. I'm not sure in my history with the commission that I've seen a regulatory package that generate this much interest and engagement this early in the process. Staff is continuing to field multiple questions for the regulated community in regard to the provisions, and these questions are being reviewed and incorporated into the package as we go along. Prior to posting the draft package, staff held a discussion with the California League of Cities to identify their primary concerns and plan to have additional discussions now that we have some draft language prepared. Since posting the drafts just 10 days ago, all legal division attorneys were assigned to go through the package and provide in-house comments, and then that generated numerous, possibly dozens suggested revisions already. And just this week, we had another meeting with Common Cause, and yesterday received another insightful public comment letter from the League of Cities. So these meetings and discussions have generated numerous proposed ideas and clarifications, many of which still need to be examined for inclusion in the packet prior to the adoption meeting, which is currently scheduled for April. With all of that, I think the best approach would be to go through the current draft package and briefly discuss each regulation in turn. It's a bit overwhelming, but hopefully we can kind of address each thing as we go along.
Sounds good.
Moving on. So starting Regulation 18438, this is the regulation codifying the Commission's opinion in a Kendrick opinion, which was adopted at the December meeting. The proposal clarifies that contributions made prior to January 1st do not disqualify an officer from decisions made after January 1st. The proposal also clarifies that an official would not be prohibited from accepting contributions from a party or proceeding if the proceeding was completed prior to January 1st. Since the posting of public comments, the issue has come up that it's not clear what this means for violations that occurred prior to January 1st, now that the former section is not there, and whether or not that somehow gives immunity. That's definitely not the intention, and we will be looking at the language to see if there's a way we can clarify how the previous section still applies to certain officials. So I would pause now and see if there's any comments or direction from the commission on this particular regulation.
Any questions on draft regulation 18438? Okay. All right. Please proceed, Mr. Love.
Moving on, Regulation 18438. This regulation defines officer of an agency. Proposed revisions would delete language related to the repealed exception for agencies directly elected, define officer to include all elected officials and all candidates for elected position consistent with the definition of officer provided in the statute, and specifically define constitutional officers. I will note that there was a fourth proposed revision to remove existing regulatory language excluding members of the governor's cabinet from the definition of officer. However, since public posting, staff discussions have generated some additional concerns in deleting those provisions in their entirety. I think staff thinks there's still a little, they're drafted as a exception to the term officer, which I don't know is supported by the statute, which is pointed out in the memo. But there's also the fact that the governor's office is an exempted agency, so many of those discussions would be part of the discussions of the governor's office. And so there's thought that those kind of communications would be exempt under the exemption for the governor's office. So that's something we're going to be moving forward and examining further going forward.
The exemption that you're referencing is something that's been on the books for some time, is that right?
Yes, it has been on the books since the initial, in the early 80s when these were first adopted.
So for 30 some odd years, this has been in our regulations. I guess my question is, do we have an understanding of why that exemption was placed in almost 30 years ago?
We have been through the regulatory files and have not found a justification or an explanation of why they were included at that time. So we were working. So, like I said, these were drafts. We're trying to get them out there for comment. And our initial thought is it was difficult to justify the exception based on the definition of officer. But as we pondered and debated this internally, we realized that there is the exception for the governor's office, and that could be the justification of why it was included many years ago. But we don't have that in any kind of written document.
Thank you. Commissioner Wilson.
Thank you for the presentation and all the detailed materials. In terms of historical reference, this might be a long shot, but you might want to check with the Legislative Council. I know that they advise the governor on certain matters, and so from a historical perspective, Legislative Council, it's my understanding, they archive decades of opinions. So, as you do your research, you might be able to find some information through that route. So, thank you.
Other questions or comments for Mr. Lau on proposed amended regulation 18438.1?
I had one, and it's perhaps you would have gone to it, and I think it's, I think I'm in the right one. 183. Yep. This is also the one that adds, and also a candidate for elected office. If I am looking at it correctly, it's on the second page of the draft, sub 4.
Okay, right.
And I think that's to reflect what the statute itself had in language.
Correct.
This is really just trying to understand. Maybe I'm making it more difficult than it has to be. So this could be someone who's not, I want to clarify for the candidate that covers. Okay. That if they're a candidate for an office that is not exempt. Let's say there's somebody who serves on a board of supervisors and they're running for assembly. They're running for an office that's exempt from this, but they are a board of supervisors, which is not exempt. If they are, so that we're supposed to capture that scenario.
This is drafted. So if you have someone, county commissioner, city manager who's running for state office, the idea would be they would not be allowed to participate in any kind of permit that was appearing before them as a employee official with the city, related to anybody that's given them contributions to their other whatever they happen to be running for,
and regardless of whether they're running for something that's exempt,
or their own agency or any other.
I was just making sure that since an assembly or senate, sometimes they run for supervisor. But they're also exempt. I'm assuming that this language is only intended to capture people who are candidates who are sitting on a non-exempt position, not somebody who's an exempt position who's running for one that is not exempt.
Yeah, I believe that's correct.
I just wanted to have that clarification.
It's looking at the decisions and what they're participating in at the moment. So.
Okay, gotcha. Thank you.
I had one final question for you. I noticed that in regulation point 1, we are defining constitutional officer. It's on N8 on page 2 of the proposed language. And in reviewing your memo on page 4, you refer to an attorney general opinion, 82 Ops Cal Attorney General 172 from 1999. They include the State Board of Equalization among the offices that are statewide. And we do not in the definition. So can you explain? I understand there's a reason for that, but can you clarify on the record why that is?
Okay, there is a reason, and the reason is because the State Board of Equalization has been providing a specific exemption in the statute itself.
Just wanted to, for the record, make that clear. Okay. All right, any further questions on point 1? All right, please proceed, Mr. Lau.
Moving to point 2, just kind of a little bit of background, just to reiterate, there are 2 key provisions. First, the officers are prohibited from accepting, soliciting, or directing when a proceeding is pending and for 12 months after the final decision. Second, an officer may not take part in a proceeding pending before the agency if the officer received a contribution from a party or participant in the previous 12 months. Interpreting this proposal currently defines when a proceeding is pending for purposes of applying the prohibition on accepting, soliciting, or directing a contribution by limiting it to a pending proceeding pending before the official. However, this is defined broadly to include any proceeding the official is aware of that might foreseeably come before the official. Therefore, limiting pending in this way incorporates the reason to know standard while still ensuring the officer cannot accept, solicit, or direct a contribution once the proceeding is known to the official. This language has not been included in the prohibition on taking part in the decision, which applies to any proceeding before the agency, as the proceeding is already before the official in making the decision and is already known to the official. So that's kind of the reason there's two different standards laid out here. The most significant issue with this regulation that still somewhat needs to be resolved is the defining attempts to define what is known and when an official has reason to know. We'll talk about this more when we get to point 7, which kind of tries to define, which is our existing definition, is trying to define that term. But that's kind of an overriding theme through a lot of these regulations. It's just trying to define at what point should official know or have reason to know. So with that, I'll take any questions on point 2.
All right, thank you. I'll begin by asking you this question. Prior to SB 1439, did Government Code Section 84308 use the term pending and pending before an agency, both of those terms, in the original version of 84308?
Yes, it did.
And since that has been on the books for almost 30 years, did we at any point before today propose defining those terms differently?
I believe we've always incorporated the reason to know, the know and the reason to know standard into all the proceeding through our definitions in point 7. So I don't think we tried to make this distinction. We didn't try to get this specific as to what's proceeding and what's proceeding before the agency. It was kind of unnecessary. There weren't a lot of questions. So we're trying to get a little more clarity there. I don't think we're trying to change how we historically interpret it, but we're trying to point out how it is interpreted, in that when it's a matter of accepting or soliciting a contribution, there needs to be something known to the official. And that's why we kind of try to do it this way, is kind of to emphasize that point.
Okay. As between pending and pending before an agency, is pending intended to be a narrower, more narrowly defined term than pending before an agency? I'm trying to understand the relationship between those two terms, since we're just now trying to parse them and give them.
I'd say yes. I mean, pending before the agency, as a general matter, would be anything pending before the agency, just on its face.
Okay.
Pending is an attempt to limit what pending is to the official when they need to know whether or not they're allowed to accept or solicit a directed contribution. But the reason you don't need to define pending before the agency any narrowerly than what it says on its face is that decision is already before the official. So that question doesn't arise, and we don't need to try to define it any differently than what it says on its face, pending before the agency.
Because the context for subdivision B, pending, is where the question is whether the official can accept a contribution.
Correct.
When something is pending unmodified.
Correct.
Correct. Under the proposed definition B2, you refer to the officer knows or has reason to know that an application has been filed, ... and that it is foreseeable the decision will come before the officer. Right.
Right.
So my question is, if you're a city council member and there is a matter that is pending before the planning commission, are you under B2 charged with the knowledge that that is pending before the planning commission under this regulation?
If you are aware of what's pending before the planning commission, I know some jurisdictions may provide lists to the public officials what's pending before the planning commission. It would be for now. I mean, there's a lot of room that we have left in trying to define knows or reason to know. I think right now, based on everything that's there, it's going to be looking at all the facts available in that particular instance. If the official made a comment at a public meeting that he knows this application's in the planning commission, you can take that as knows or reason to know. I don't think the current draft right now requires some sort of knowledge of everything that's happening within the body of the city. So I think at this point, no, they would not be like, there's not some sort of presumption that they have to know what's happening at the planning commission. It's just a matter of what do they know is happening at the planning commission.
and what they know under this regulation today is contemplated to be a question of fact that would be determined on a case-by-case basis?
I mean, right now, the only standards we have in here is no's and reason to know. So
I'm trying to, part of the reason I'm asking the question, and by the way, let me take a step back. I think you guys have done a great job trying to get us to a point of identifying the decision points, because this is very complicated, and this law is now being extended to thousands of new public officials, right? So don't take this any way other than I'm trying to put myself in the position of a local public official and understand what my obligations are. When am I going to be charged with knowledge? If there is something on the agenda of the Planning Commission, and I don't look at the agenda that month, but it comes up later on that matter was on the Planning Commission agenda, and I accepted a contribution from somebody, am I in trouble? Or am I not in trouble? Am I charged with that knowledge? Am I not charged with that knowledge? So that's the spirit in which I'm trying to sort of get down to the granular level of these.
I mean, I think as it's drafted right now, it would not cover the idea that you would be reviewing the agenda of every of every entity within. Let's just say you're an official in LA. You're not. I don't think anything in here is requiring anybody to review the agenda of every body and board within the jurisdiction of LA. I think what it requires is you review your own agenda and know what's in there, and then after that, it is a matter of what is known and what are the facts, what is known of the official, and which is a case by case analysis. I mean, I think that's the way it's contemplated in the existing regulations. Like I do. I have more of this when we get to point 7, but I mean, we definitely recognize that this is where everybody in the regulated community is focusing on as a primary concern. If you look at point 7, when we get there, we haven't done a lot as far as the existing standards that were there. We've tried a couple things, but other than that, we haven't broken down each one of those definitions and tried to attempt that. We are working on drafts. We had part of our internal staff meeting was going over some of the ideas of things we might be able to do to start trying to define this with different elements, different criteria. We're not there yet, but I mean, we feel like we're getting close, sir, to providing those kind of revisions. So I think it's definitely on our agenda, and it's definitely something we are considering and looking at.
All right, I appreciate that. Other questions? Commissioner Wilson?
Kind of have a related question. First of all, Mr. Lau, excellent work on outlining all of this. In the example that the chair referenced, in terms of the knowledge that one is expected to know as an elected official, if let's say you had a situation where you're on a city council and you have staff that prepare you for your council meetings, is there any obligation if a staff member knows or should have known that there was a matter pending before, let's say, the Planning Commission, is there any obligation of the staff member to inform the city council member? Because you could have a situation where the city council member knows all the facts, but they decide, I'm just not going to tell the council member this. He or she doesn't need to know it, or they choose not to inform the council member.
I mean, just looking at the language in the statute, my answer would be it would matter. What matters is whether or not the officer knows or has reason to know, and I don't know that there's anything. There's nothing currently that would require review, examining your staff and clarifying whether or not they have anything that they need to be told prior to a meeting. I mean, there's no affirmative duty to take those kind of actions or steps currently in the regulations or within the statute.
That was kind of my assumption, but thank you for the clarifications.
Commissioner Baker?
Thank you. And I also am grateful that you're helping us all walk through every scenario that is reasonably foreseeable and how to make it workable. I'm going to throw one at you that I'm sure you've already thought of, but it builds upon this city council member, and there's something before a planning commission. And let's say, are we anticipating not that they look at the agenda of every planning commission meeting, but there are different news outlets in that community that may cover it. And there's lots of council members who presumably are keeping track of all the news that's in their community, but maybe not everything. And how much of that news coverage can fall in the should have known, I think is something we're going to need to work out. I don't know that you have an answer at this moment. And I have a part B to that. which is, council members are out in the community all the time. And someone can just come up to them and say, hey, I don't want this housing development that's before the planning commission or whatever. And that might be the first time the official has heard about it. But is that now, okay, you've now become aware of it because an individual in your district has walked up to you and shared information with you, even though it's not currently before the city council. Those are very, very common scenarios. And if whatever guidance we can provide or be thinking through on this should have known, I think they need to include those scenarios for sure. I welcome other.
I can say I've thought about, like the news coverage and what's generally known to the community as part. I think it's, like I said, it's hard to get to any kind of affirmative duty to seek something out or to expect them to see something just because it's out there. So at least when this is just me personally, when I'm visioning this happening, what I see is something being announced at a public meeting. Somebody, regulated community, some interested person standing up and saying, here's a newspaper article. They have a proceeding before the planning commission. I mean, I think we would expect them to know what was brought forward to them at a public meeting through the comments and through the discussions there. I don't know what we would expect outside of that scenario, though.
Very, very. That does seem like a very, very narrow way of information coming to them is whatever's presented at that public meeting. But I see the chair is ready to dive into that.
But I'm just saying that as a factor of what would lead us to say you should have known or what. I mean, there's other if enforcement hears of a case and they subpoena emails and there's emails going back and forth and it's obvious they knew about it. I mean, you could have that based on whatever is out there and wherever they receive that information from. Proving knows is very difficult, but at the same time, we're trying to define it as best as possible.
Yeah, and certainly we're trying to avoid a situation where a case even gets before enforcement as people are trying to comply.
Right.
As well. So I don't have a solution on that one, but those are the scenarios that I just have to really be thinking through, of course, with the many others you've already thought of.
So sticking with that example in your last response, where we're talking about a public official in the context, I think, of a public comment pointing out a newspaper article, and you talk generally about their knowledge of what's in the newspaper. So make it more concrete, though. This provision is a prohibition on accepting contributions, right?
Right.
What is, if any, the cure provision that applies to this section of the statute? Like if I accept a contribution, right, what are my options for returning it and curing an unintentional violation?
So if you're learning that you, at a public meeting, that this person somehow gave you a contribution and there's a proceeding that you just found out about through the public comment, the cure provision would give you 30 days to return it prior to participating in a decision by that board that you're sitting on. So there is a cure to allow you to participate in the decision.
Is it 30 days from the time of the decision on the pending application, or is it 30 days from the time you are made aware of something being pending under subdivision B?
I think it'd be 30 days. I can double check this. I think it'd be 30 days from the point that you are aware that there's a proceeding and that you had a contribution.
Okay, so that's different than the decision, though. Now, that's an important distinction,
Right.
I think, because now, suppose that there's a newspaper article, and it's not at a public meeting. It runs on January 1st, and I'm sitting at the council meeting, and it's February 10th, right?
Right.
Am I charged with the knowledge of that newspaper article from January for purposes of deciding whether I had to return the contribution? Because I'm beyond the 30 days.
The way I view it is that you would not have any kind of duty just to know what's out there generally in the news.
Okay.
The duty what I see is a duty when if somebody's showing up at that public meeting and say, look at everything in the news and brings it to your attention, that's the point that you have a reason to know. But I don't know that I'm not trying to attach any kind of reason to know standard just because it happened to be, it made the newspaper a month or two ago. I wasn't trying to create any kind of knowledge based on those situations at this point.
Okay, all right. I just wanted to clarify that because that's an important, I think, distinction. I had another question for you. I was just looking at the statute itself, and I'm looking at 84308B, right? And that is the provision that we are trying to implement through regulatory paragraph B, defining pending. And I note that in the statute, it uses the the official knows or has reason to know standard in relation to whether the participant has a financial interest. It doesn't use that standard for knowledge of whether something is pending or not. And I wanted to get your commentary on why, if you see any issues with that standard being used in a different context in the statute than what we are attempting to apply it to through the regulation. Because I think it's different.
Okay.
Pending, when something's pending, is different than whether or not you know something is a financial interest.
So
of a participant.
the statute here is using knows or reason to know in regards to whether or not the participant has a financial interest. Parties always, under the statute, parties always have a financial interest. So that standard doesn't apply to the parties under this section of the statute. We're using knows or reason to know not to decide whether or not somebody has a financial interest, but in this context, we're using it to define when they know of a proceeding, when they know of a contribution. We're using it for other purposes than how it's being used here, is what I'm saying.
I agree.
Okay, this knows or reason to know, it's like an overriding theme throughout these. It gets a little intermixed and it gets confusing really fast, but it applies in multiple circumstances. Was there a contribution? Was there a proceeding? Did I know they had a financial interest? So we're trying to define it for multiple scenarios or for multiple purposes as well.
Yes, I understand what we're
Okay.
trying to do. My question is, when the legislature used that phrase in a different context, and we're now taking it and importing it into a different context through the regulations, do you see a problem with that? Because the legislature did not choose to use the know or reason to know standard with respect to defining pending. And if you don't see a problem with that, that is fine. I want to ask the question because I noted that in the statute.
I think as a matter of practicality, we have to do something. The idea that somebody who's in the jurisdiction of LA or some large jurisdiction would know or would be subject to this prohibition on accepting or even soliciting a contribution prior to anything coming before them in their official capacity would lead to very harsh and very, I think, unintentional results. So I think we have to do something here, and I think using some of the methodology that they use for other purposes makes sense. So I don't see it as an overriding problem. I see but I understand your point that it wasn't used in this context in the statute.
All right, I appreciate that. Commissioner Baker?
So I want to go back to this point. It is a statutory construction that if the legislature used a term in one place and they had something different in another place, it was intended to be different. I think that's a statutory construction. I think it's in your memo. Yeah. So I start to get a little bit nervous where they've used specific language with that well-known statutory construction out there, and we are then going to say we're going to have to come up with something to read into that or make it practicable, as opposed to they've got to go back and fix it. So this is pre-notice. That's going to be an overarching feedback for this commissioner, and there's a few other areas where it comes up where the statutory language seems to be very specific, and we're trying to find a workaround that's beyond filling it out. It could be potentially changing it, and I just caution us from doing it. And this may be one of those areas. I'm just nervous about changing terminology because it could have a really hard way to apply in Los Angeles. That might be what we're stuck with, and the legislature needs to fix the legislation. I don't have a proposed solution, which is awfully handy of me not to have, but I just raised that concern about how we comply with tenets of statutory construction instead of just sending it back to the legislature to fix.
Yeah, Commissioner Wilson?
This is just kind of a general question. Is there any indication in the legislative record why the legislature changed the language?
This is Dave Bainbridge, General Counsel. I'll jump in because I went over to the State Archives last week, looked to see what was in the file for when the legislation passed and was amended, and so that was a fun little research project. This language that we're talking about in the statute has not changed. To Commissioner Baker's comment, in B, they use the term pending. In C, they use the term pending before the agency. So you can say they're using the same word pending, but they're not using the same phrase. So I think you can argue it either way. If you look at just the word pending, yes, same phrase should have the same, or same word should have the same meaning. Here, the phrase is different, so you could argue they intended something different by not including before the agency after pending in B, which was part of our reason for thinking these could have a different meaning. So to answer your question, no, there's nothing in the record that explains whether that was intentional or whether that was a drafting error. It's been there since they amended the statute in '84, I think it was. But we think from a practical application standpoint, it makes sense to define these slightly differently. And because they're different terms, although the same word, we think there's justification to define them differently.
And thank you.
Can I just ask a follow-up though? Can you give us a little bit more gloss on why after 30 years we're just making that determination when for the prior 30 we didn't define those terms differently?
Because this now applies to a different group of people. We didn't have the issue in the past where it applied to, say, city council. And we always say LA because it's the biggest city. But you could even think of, say, the city of Oakland. It didn't apply to the city council members. It applied to the appointed boards. The city council is much more likely to have something that is, say, with the department, some department within the city, which is underneath their umbrella agency that they're not going to know about. When this just applied to, say, a planning commission, it's less likely that you have this issue where there's something pending before their agency that we don't think they should have knowledge of. We think it's more likely now that it applies to a much broader group of people who have much bigger agencies to believe that there's a likelihood that there's plenty of applications that they're unaware of.
And may I would just want to additionally add, because you mentioned why we haven't done this differently over the last, we have done this differently, we have done this consistently over the last 30 years. In 0.7 now, there's existing language that says an official we've used a official knows or has reason to know standard for determining when there's a proceeding. And that's in 0.7 now. It's been there since these regulations were adopted in the 80s. We have been using this standard in this context for the last 30 years.
So it's actually not a new.
It's not a new
not a new concept.
Right.
You're just codifying it in this portion of the regulations in addition to 0.7 is what
correct.
You're saying.
Right.
Okay. Well, that makes sense.
There's still some problems with the play between 0.7 and this regulation that needs to be addressed. So there's some redundancy there.
All right. Other questions, Commissioner Wood?
I want to be a little bit of a pain. Sorry. So pending feels broader than pending before the agency, but our interpretation of it is narrower because we're saying pending before the official, right? So that's tough. But then I was looking at the statutory language. It actually says pending before an agency, which then you could argue is actually broader than pending. So maybe it's fine that we do it this way, but the statutory language is pending before an agency. And I don't know that agency is defined narrowly enough, because I'm not referring back to 82003, to counter the second thing I'm seeing here, that pending before an agency could actually be broader than pending. So anyway, I don't know, maybe it's a combination of drafting challenges that let us do it the way that you guys are proposing to do it. But just facially, when I saw what was going on, and we're implicitly saying pending before the agency, which feels broader than pending before the official, right? But it's not actually the, it's an. So I want to point that out. I don't know what to do about it either.
Yeah, and it's a good point if you look at that in isolation. But C only applies when someone is in the position to make a decision on an item. So it necessarily has to be before their agency for it to work. But I don't disagree with your English language argument.
I had another question for you. So again, this is very complicated. It's very difficult. I think you guys have led us to a great starting point. My question is, have you thought about trying to introduce the concept of some kind of a safe harbor? Because I think to Commissioner Wilson's point, I think for agencies that already have staff who are in the in the practice of looking at the agendas and keeping up with what other bodies are doing, right? Like the Planning Commission example is a good one, right? If you're a council member and your staff's already doing that, you're good. You're going to be fine under this. But for other agencies where that's not the current practice, you're probably a little more concerned about it. So have we thought about introducing a safe harbor here in any way?
Yeah, we are discussing safe harbors and as a one way means of trying to address, we use this in 3 different contexts. We're looking at safe harbors in all 3 of those different contexts and how they might work. Like you don't have the affirmative duty to look at to have your campaign statement memorized when it comes down to contributions. So we are looking at safe harbors that might work on top of prior to providing some factors of what would be considered no, or what would lead us to start thinking you had reason to know. So that's what's being discussed right now. I don't have any of that language kind of to paper yet, but I mean we have discussed it pretty thoroughly at a staff meeting.
Great, appreciate it. Any further questions on point 2?
Thank you for the safe harbor suggestion. I'll be very interested in what percolates out of that, both from comment and otherwise. When we get to the next time we approach this topic, or whatever agenda it's next on, understanding what authority we have to do the safe harbor will always be a question that I'll be looking at. It's very important that the statutory construction rules better than I, but there'll be a variety of them, and that if we have the authority to do a safe harbor, if you can help us ground that in some constitutional or statutory principle. That's just a heads up on the question I'll probably ask down the road, so that we aren't. I know we try to avoid this, rewrite the law ourselves when we may not have the authority to do it, both to avoid a court challenge as well as to just get it right. So thank you. I'll look forward to that.
Okay.
Any other questions for Mr. Lau on point 2? All right, Mr. Lau.
All right.
I'll let you off the hot seat.
Point 3.
Good job.
This regulation defines the term agent. Revised language does not substantially change the definition, but language regarding the aggregation of contribution by agents have been moved to point 5, which is an aggregation rule. So we just thought it was more appropriate there. To follow up on some comments from League of Cities, the League has suggested requiring agents to identify themselves. Staff is currently examining this situation. We're not opposed to it in principle, and our initial thought is that this does require a public disclosure before you participate in the decision and by the party even. So there is some thought that the disclosure by an agent should be part of the disclosure made by the party at the proceeding. So there is some thought of moving that into that provision, which would be point 8, which is what the disclosures required of the party and the official. So we are looking towards moving that into some sort of requirement into the disclosure requirement. With that, I'll take any comments or questions on this one.
Questions for Mr. Lau on point 3? Commissioner Baker?
Mine goes to what looks like language that is already there. It's not that it's being proposed. It's sub B on if an individual is acting as an agent, is also acting as an employee or member of the law, architectural, engineering, or consulting firm, or similar entity or corporation. Both the entity and the individual are agents. So, I come from a law background. I'm trying to see how this affects, say, a paralegal at a law firm, or if a partner at a firm goes and testifies at a public hearing on something on behalf of a client, just how much that ropes in everyone else who works at that law firm or consulting firm or CPA firm. Can you comment on that? Like, how do we?
This is existing, and I think the thought is that if you qualify as an agent when you show up to speak at before the body. So the idea is the lawyer or the law firm is representing the party.
Mm-hmm.
The law firm shows up to speak. That law firm is now an agent of the party, is employed by them. Now, if that law firm's employee shows up to add additional comments on this particular permit, title, license, entitlement, they would all be lumped into the same group of agents working on behalf of that party that hired them to represent them in that proceeding. So ultimately, agent stretches to everybody within that law firm if they show up at that meeting that the law firm had been paid initially to represent this party on. So it does require them to take that step of showing up. So like the paralegal wouldn't be banned from giving a contribution up until the date that they show up at a meeting and argue that this permit that our law firm represents should go through. So I think that's how it works. And those, like I said,
Existing law.
within the existing regulation. Yeah.
So the paralegal, if the paralegal wanted to, I'm picking on paralegals today because I can't think of what it would be in a CPA or consulting firm, but if an associate or a paralegal gives $250 to a member of that city council, when the law firm partner on behalf of a client has come and testified about something, entitlement or whatever, as long as the paralegal doesn't show up and also say something
Right.
on their own individual behalf, they don't fit within agency under existing law. That's your understanding?
Right.
And by existing law, you mean the proposed regulation.
In the existing
Well,
regulations.
Right.
What I mean.
I guess the B.
The agent, and actually under the statute, you're not an agent for purposes of the statute until you show up to represent. You're not an agent that's going to be that. You're not an agent that the official will not be able to participate in the decision, take contributions from until you show up to speak on their behalf in some manner.
What if the paralegal works on that, I don't know, brief or letter or part that the partner's the one that's the vehicle for passing it on? Or again, I'm thinking of a law firm because that's my experience, but I know there's entitlement consulting firms that are in that same scenario. And if we don't know the answer, it's just I'm thinking about it as we try to.
I will think about it additionally, but I can say the idea is you wouldn't be the agent until you showed up to speak. So just working on it and not showing up to speak, that you're not the official is not going to be banned from contributions from the paralegal that happened to work on it, but did not show up to speak unless the law firm directed and controlled that paralegal in making the contribution, which gets into another subdivision.
That's a whole other violation. Okay.
Which gets into a different subdivision, which I can't remember.
Thank you. I mean, when I see that language, and I think it's coming later when we get into other definitions, I'm thinking, what I'm hearing is who's the actual voice, whether it's who's signing the letter that's submitting public comment or writing it is the one that's really being caught within the provision and not the person who maybe drafted it. As long as you're not the voice for it or the signatory that right now we're not anticipating they are covered within this.
Okay, and I'll go back. I'll just point out the subdivision A, which is our definition of what an agent is, and it requires the appearing before or otherwise communicating with the governmental body. So the way that it's been defined in the existing regulations for all these years requires that extra step of somehow speaking or communicating to the governmental body before you qualify as an agent, just because you happen to have some sort of ties with the party or other agents.
Thank you.
Yeah, I just want to, I guess, put a little bit of a fine point on it because I keep hearing you go back to, I think what you're saying is, and I accept this as a reasonable interpretation, that we're not going to consider you an agent unless you actually appear and speak.
Right.
But when I look at the regulation, if that's what you meant, then you would just say by appearing before the government agency, but you didn't. You said by appearing before or otherwise communicating with. And I know, well, I don't think we would ever do this, but it seems to me if you had a paralegal who sent the letter on behalf of the partner to the agency, that is the paralegal otherwise communicating with the government agency. Technically, right?
I don't believe we would ever call the ministerial task of mailing a document communicating with the agency. I think we would require communicating in some sort of manner that's attempting to influence the decision. We could possibly just see if it's even.
But you see how the language is broader than just simply showing up. It's otherwise, because you say otherwise communicating with the government body, which includes sending a letter, presumably, or an email.
We can look. I mean, we can clarify that and move to the point that it does require some sort of substantive attempt to contact the agency.
Yeah, I don't think you're trying to get at the paralegal, but I think it's not as clear as what you're telling us today.
Or tweeting to the government agency. That other communicating can capture a lot, but you're thinking not the ministerial part. Gotcha.
Right.
So
Sorry,
I'd
Mr.
like to ask a question about that. To me, I don't read communicating in any other way than the person who's responsible for the communication, not physically responsible for sending the letter or drafting it and having their boss sign it and send it. I don't know how we would clarify this language. If you have suggestions, I'm open to them. I'm not against what you're saying. I'm just struggling to see how we could write language that would make it more clear, not less clear than the way it's written now. And I think the common understanding of who is responsible for a communication.
Yeah, well, let me ask you this. Do we have an advice letter that makes clear Mr. Lau's interpretation of this? So where if I'm a paralegal and I send it on behalf of the partner, you're not going to tell me my contribution counts for the public official.
I would say we use this appearing before or otherwise communicating with in the context of conflict of interest. And we say, you are banned from attempting to appear or communicate under conflict of interest rules and revolving door rules if you are doing it for the purpose of influencing the decision. So that's how we've always this language is normally tied to for the purposes of influencing the decision. So I think that's the intention that it was used here. Similarly, it just doesn't have that extra verbiage at the end of at this point. So I think there is a way to clarify it, just using some of the similar stuff that we've used in the past.
Yeah, and I'm not ascribing ulterior motives. I accept your representation of what we're trying to accomplish. Part of my concern here is you're borrowing from conflicts for something that has to do with not allowing somebody to accept a contribution. And that raises other considerations in my mind that we should be very clear about where the dividing line is between who can contribute and who can't. So if you can clarify it, I'd like to at least give a shot at it. Do we have other questions or comments on point 3?
Well, all this paralegal talk has me wondering if we're setting up a system, or maybe the statute sets this up anyway, where the paralegal can be the vehicle of all the contributions from the law firm, or a set of them, the 7th floor, right? And then they just won't be involved as agents because the law firm already will be, because the partners just won't be donating because they're the ones doing the speaking. Maybe we don't care about that, but I wonder if the spirit of what the law wants us to do would be violated if
it's been contemplated, and we are moving towards within the proposal we have language that you consider the party anybody that party is or agent is to include anybody that party or agent is directing and controlling. So that's where we would pull in the paralegal who's doing it as a conduit and is being told by the law firm, here, make these contributions on our behalf, or doing it for that purpose. So we have thought about it. We tried to resolve it the best we could with the direct and control standard that we'll get to in, I don't know. I can't keep track of the numbers myself.
Any other questions on the point?
No, but thank you. You're doing great work here. It's so hard.
All right. Thank you, Mr. Lau. Please continue.
I think we're done with 3, correct? All right. Point 4. This regulation defines when a participant lobbies or testifies in person or otherwise acts to influence a proceeding. Only minor non-substantive changes have been made at this point. The League of Cities did mention that it was counterintuitive to consider written documents lobbying in person, and suggesting that we move that to the otherwise influenced section of the definition. And we agree, and we'll be planning on making that change.
Any questions on 1843.4?
Yes.
As somebody who appeared at all of these meetings remotely and before today, I wonder, where does Zoom fit in? Is this like, if you're appearing remotely, are you lobbying in person?
I would say yes. I at this point, I think the idea is anything done electronically through Zoom meetings is basically the same as the live and in person.
Testifies in person, I think. Makes an oral statement before an agency. I think that works, but lobbies in person, communicates directly either in person or in writing. Do we need the in-person language there? This is old language, right?
This is older language.
Okay.
Well, I think at a minimum, it's in person or electronically, I think was Commissioner Wilson's suggestion. Because I think that's a good point. I mean, we ought to be thinking about that for all of our regulations, really, the prevalence of Zoom.
I would say, just as we could clarify that with some electronic language. This is kind of if you do any of this, you qualify. So as long as it's caught in one of the 3, we're in a safe area. Like we're not missing anything as long as it's caught within one of these three versions of the definitions. So anything that doesn't necessarily land in lobbies in person, that lands in otherwise attempts to influence, would still be covered. So it's not the idea isn't that.
I just think that, your point is outlined very excellent way, but I also think it's important to clarify, down the road if someone says, well, I testified via Zoom, so I'm not covered. I'm sure that an advice letter would capture that scenario, but to include electronic communications, in the regulation and to clarify it would be helpful.
Okay.
All right. Any other questions on point 4? All right. Please proceed, Mr. Lau.
Point 5, for determining whether a contribution of more than $250 has been made, this regulation requires aggregating all contributions from the party or participant as well as the agents of the party or participant. It also clarifies that the party, participant, or agent includes subsidiary businesses, related businesses, or individuals that direct and control that entity or individual. And that all these contributions from these people that are included within those definitions should be aggregated as well. The one issue that has came up is that the draft currently says directs or controls, or actually says direct and control. There is a typo. There's an S going in. But I also agree with it, the idea that we define direct as for purposes of in a different regulation here, we define direct as something limited to like requesting for somebody else without necessarily having control of anything. So I actually think I agree with the comment that this should be directs and controls. It's not that they just asked somebody to do it. It's that they asked somebody to do it and have some sort of level of control over that person.
Any questions for Mr. Lau on point 5?
Yeah.
Commissioner Wood?
One of our commenters suggested that we change in subpart 2, first employed by the party or participant to first engaged by the party or participant, to bring in, I forget the language they use, but something like, independent contractors and things like that. I agreed with that, but I wanted to hear your thoughts.
I think we're going to search for a better term than employed. I think maybe that suggests a level of them actually working as some sort of on the books employee that we weren't intending. So we are going to look for a better word than employed. And whether or not engaged is it, we haven't decided yet.
Gotcha. Thanks.
Any other questions for Mr. Lau on point 5? All right.
Point 6. This regulation defines accepting or receiving a contribution as well as soliciting or directing a contribution. Generally, accepting, receiving, soliciting, directing are all easily understood. The issue that has arisen is whether the prohibition applied to contributions accepted, solicited, or directed to other candidates and committees, such as a ballot measure committee or a office holder account. In regards to this issue, I will quote directly from the statute. This prohibition shall apply regardless of whether the officer accepts, solicits, or directs the contribution on the officer's own behalf, or on behalf of any other officer, or on behalf of any candidate for office, or on behalf of any committee. I think they painstakingly tried to articulate the point that this has to apply to any attempt to solicit, direct a contribution to any candidate or committee. So the draft was intending to try to capture all committees, including ballot measure committees, including office holder accounts. We will look for language to clarify that point. That was actually something we talked about at the staff meeting, that we don't think the existing language quite gets there, and it's the way we discuss other committees when we in the campaign manuals, but it's still missing that express. We're including all of the following language, so we are looking to add that.
Any questions?
Any questions?
Any questions for Mr. Lau? 6.
Just a quick
Commissioner Baker?
There's other parts of what we've addressed in the last few years that have this idea of direct or seek a contribution. And I'm thinking of behest payments. How does this language compare to how we use the same idea of direct or solicit in that context?
I haven't made the comparison, so I don't think I have a good answer for you.
I was wondering how much we're being consistent with elsewhere, knowing that sometimes it's different, but it's very similar in the behest payment area. I think we've gone to the trouble of defining or using language that makes it clear when someone behests a payment. And I just, I can follow up with you separately to take a look at that and see if it's similar so that we're, if appropriate, just consistent in what we're using elsewhere in a very similar context.
Okay.
All right, any other comments on point 6? Commissioner Wood?
The League of Cities asked about the mixed use between officer and officer or candidate.
Yes, that's been identified as inconsistent already, and we will be working. That's just existing language and stuff pulled from the statute. This used kind of intermixingly. We will plan on trying to make that usage more consistent throughout the regulations.
Great. I just, candidate for elective office in an agency is already defined in the statute for officer.
Right.
So I think you could just drop the candidate side.
Right.
Yeah. Okay. Thanks.
All right, the fun one, point 7.
It's where all the answers are, right?
Where all the questions are. This regulation currently defines when an official knows or has reason to know that a person has a financial interest in a proceeding, when a proceeding is pending, and when a contribution has been made. Existing and long-standing language has been mostly retained in the proposed drafts, but staff is aware clarifying this issue is a primary concern for the regulated community. While some clarifying changes have been started, staff views this regulation as a starting point for further discussion and hope to offer significant improvements prior to the adoption meeting. For now, I'll emphasize that staff is currently working on language to further define when an official knows or has reason to know and when an official willfully and knowingly receive a contribution. One issue that keeps coming up is whether the official has some sort of affirmative duty to check campaign reports prior to taking part in a decision. As currently drafted, staff does not intend to require full knowledge of all reported contributions or an affirmative duty to always check campaign reports prior to taking part in a decision. As these, for a large campaign, this would be this could be problematic, and it would also be problematic anytime the official first learned of a participant at a public hearing. However, there has been suggestions that an officer should be required to review for contributions if a party has been specifically identified in a public agenda in relationship to a permit, license, or entitlement coming before that officer. Meaning, when that agenda goes out, the city would note that here's an entitlement. This is the party that's applying for the application, and the officer and there would be an expectation that the officer refers back to campaign reports to see whether or not the contribution was made prior to taking part in the actual public meeting on the issue. So that's something that's been thrown out as an idea. It keeps coming up. At this point, staff is open to suggestions. Staff this is one of the areas staff would like to get some of the commission's direction on as far as what level of action should be required of the public official in consulting their campaign reports. And other than that, and we can come back to discuss that. But the other thing we're doing here is there is a section that would allow for officials who first find out at the public meeting that there is a contribution and they're not allowed to participate in this decision to actually participate in the decision if they announce that they will give the contribution back in 2 days, if they're still and follow through with giving it back in 2 days. There's some issues at the moment as far as whether or not they have to make that announcement before the discussion starts, which is how the draft is drafted now. It's been pointed out that sometimes they won't come out till the public meeting, so we anticipate some revision to correct that. But that is modeled off of a similar exception for gifts, which gifts has a provision for return. So the idea is, and there's a similar exception in gifts that allows the official to participate in a decision and give the gift back within a certain time period. So, like I said, this is still mostly questions in need of answering as opposed to a concrete proposal at this point. So
Questions for Mr. Lau on point 7? Mr. Baker?
Thank you. On that last point you were referring to, which in your staff memo is on page 8, it's kind of summarized the idea that if you find out
Right.
on the fly, it's happening right there, and the official knows that the official can participate as long as he or she returns the contribution within 2 working days. I'm kind of repeating myself here, but how can you explain either now or at a future meeting the statutory authority to make that kind of change to us to be able to do that?
Okay.
Again, you may not have it at your fingertips, but that'll be a question I'll be interested in. That may make all practical sense if we were to all agree on that. I just don't know if we have the authority to write, if that's basically rewriting the statute too much, as opposed to we need to ask for the legislature to make that change.
okay.
Any other questions for Mr. Lau on point 7? Going once.
No, don't take it away because I do have a question. I'm trying to
See,
formulate it.
Yeah.
So I think, I mean, when I clerked for a Ninth Circuit judge, and I walked in the chambers the first day, and there was a list of all of his investments. And he said, if any of these parties comes before me, I need to, I mean, I don't know that he affirmatively was ready to recuse at the moment, but he wanted to know, right, from an ethical perspective. So he kind of was ready and sitting on go to do what he thought was the most ethical thing, right? And I've never run for office and never planned to, but I have worked a lot with campaign finance data in my job, and it's really not hard to pair up the parties at issue with your donor list. And so I think that in theory, that could be something that could be required. When I read the language in the statute, it says if the officer has willfully or knowingly received a contribution in an amount of more than $250. Yeah. And I don't know if I don't know how to make those two things go together. Because it says willfully or knowingly received, which is in the past. And are we putting a burden on you now to find out whether you received? But I don't know that would be willful or knowing. You see what I'm saying? Now, there's other language. This is why I took a minute to start speaking, because there is language in here that has accept, but now I can't find it. And so you, of course, accept. I assume you accept a contribution when you don't return it, I would assume.
Right.
And so if it fits under the part where it says accept, which I can't find right now, then maybe it would be okay to expect them or somehow require them to check. But I would also be interested to hear from Commissioner Baker on this because she's the one who's run for office before.
I'm finding received. No, that's totally fine. It isn't that difficult to find out who has contributed to you, even before the reports that get filed that are the subject of a lot of what we do. And it did raise a flag in my mind as well as how are we really not expecting people to do this? If you knowingly have received something, how hard is it to impart knowledge that you've received a contribution? I don't think it's that difficult. I also, as an official, is like, look, these are my financial issues. Make sure that if anything comes before me, I'm going to know well in advance. I'm one person. I have an issue with just kind of keeping it off the table that you're not imparted to have some knowledge at all. It seems a little bit like too broad a brush to paint. I don't have language to propose, but I think I share the concern, and I know that where it becomes difficult is if you receive a lot of contributions and it's going to take like a few days to figure out, like, do you want to, within a week of receiving the contribution, it comes to you that happened. I'm sure that we have dealt with that before in other contexts, and perhaps, Mr. Bainbridge, I see you looking near the microphone a little bit, but have we dealt with this in other settings where we think someone is imparted to have knowledge of contributions that have been made to them knowingly?
Yeah, that's quite. I mean, this is kind of an age-old question: is do you have knowledge of the contributions you've received? And it's been an issue in many parts of the act. I don't know that it's been resolved to this date. We'd have to, I think, really think about it and look over the record. But it's a good question to have and to hear what the different commissioners think. Concerns we've heard from the regulated community is particularly with the participant, meaning the person who stands up at the meeting and says, I disagree with this permit being issued. We think that would be an unreasonable situation to expect the council member to know immediately, oh, that person gave me $200 11 months ago. Party, I think you do have some notice of who's going to be the party coming before you. So I think it's a good discussion for us to hear from the commissioners and get their position on it. I think in some, it also, you have to think about in a small jurisdiction or someone with very few donors, they know who their donors are. There you have actual knowledge. When they have pages and pages of donation, of contributions, it's a lot different situation. So I'm just giving this all as perspective for you to think about when deciding where you come down on this question.
Let me say that was my situation. I've seen this situation. You have many, and sometimes the names are not ones that are, maybe you have bad memory, but their names are not ones that are going to stick in your mind. And so we do need to think about that, is how much we are going to remember what threshold somebody hit and if they are on your report you might have.
I would just add one more thing for everyone to think about, is the intent of the law is to prohibit someone having the fact that they have received a contribution influencing their governmental decision. So if they really don't know about the contribution, is it influencing their decision? So this is what we've been wrestling with over the last couple months. So I'll share it with you.
Yeah. So what's kind of wild about this is if we have everybody go through and figure out who their donors are, and then and they didn't know before, and then some of those donors stand up and express a view, then we're actually, I mean, this is just what transparency can do, right? Is like creating a situation where they may feel a little bit more obligated or a little bit leaned on in a direction that they otherwise might not have. I mean, I'll just, not to say it out loud, but I'm saying it out loud. Like, this can be one of the perverse things that transparency could cause.
That's right, because if the contribution came in between dates of a report being filed showing that contribution, then the public wouldn't know about it. The official may not know about it, but they're learning about it. And then you're right. It is, now you actually are, maybe you're going to listen more carefully because they're telling you that they've made the contribution. So I think that's a good point when we're trying to sort this out. I actually have a question, since we're talking about the party's obligation to disclose that they made the contribution. I see that as an obligation. What's the remedy, if any, if a party stands up and advocates for or against a project, they've made a contribution, but they don't disclose it?
Well, I think you have obviously the party that is in violation of failing to disclose. As far as the official, I don't think the official is automatically off the hook because the party forgot to disclose or failed to disclose. I think it then goes to whatever the standard is going to end up being, is what was known and what should have been known by the officer. Obviously, they didn't have the benefit of the disclosure, but if there's any other evidence or indication that the officer knew, or that there was other reasons out there because somebody else stood up and said something at that same meeting, if there's any other indications of knowledge or reason to know, then that officer is not completely off the hook, but it would definitely be a harder case to get into as far as trying to make that determination.
Right. From the standpoint of the party, though, are we in a position, is what you're saying, that party has now violated the Political Reform Act and they are subject to a fine of up to $5,000 per violation for failure to disclose?
That's my reading of it. My reading of it is a ban on that parties and participants are not allowed to are not allowed to give contributions and are required to make this disclosure, and failure to do that would be a violation of the act.
Okay. I think that is something we haven't focused on yet, but I think we're now talking about members of the, what I would just say is like members of the public, really, having to be more aware when they come to speak at these commissions and meetings if they have made political contributions in the past. And I think we're very focused on the public official and their obligations. I think we can't forget there's that aspect of it as well. So, Commissioner Wood.
I doubt we could require this, but I've been thinking about this the whole meeting, which is, I'm thinking about these parties. If they've applied for some kind of a permit or license or whatever, I wonder if what cities will do is, as part of that, they'll notify the parties, like have some kind of notice in the application itself that says, if you're a contributor and you want to have communications about this, you're going to need to disclose to the officer. I don't know that we can require cities to do that, but it seems like it would be a helpful way to help the parties. I just don't know if we have the jurisdiction to do that.
Well, at a minimum, I think that will become a source of referrals, I imagine, to the enforcement division every time a party is not making that disclosure. So definitely a potential spike for enforcement's workload. I did want to follow up to something Commissioner Wood said. We were talking about the standard of knowingly and willingly, right? And if it happened in the past, how could you ever say that you knowingly and willfully accepted it? I went back and I looked because I think that's a really good point. But maybe I'm missing something. But doesn't that standard only come into play for contributions that are received after the decision is made, though? So this is the post-decision contribution ban where that standard comes into play. So you actually have, I thought, made a decision, and so now I think it makes sense to have that knowingly willingly. But am I missing something?
Yeah, I think in C, the willing and knowingly applies to the taking part in the decision. So if you knowingly or willfully or knowingly received a contribution at some point, you're not allowed to participate in the proceeding. So that's under C.
Okay. Yeah. Well, that is. Yeah, I think that's going to be a challenge. Let's sort that out. Okay. Any other questions for Mr. Lau on 7? All right, please proceed.
Point 8, this regulation specifies the disclosure an officer or party must provide for the public record under Section 84308. No substantive changes are currently proposed. However, our meeting with Common Cause revealed that the regulation is not entirely clear as when the disclosure by a party is required in describing the proceeding has commenced. So we are going to examine that kind of language and whether or not we can have a more appropriate trigger. There's also talks of whether or not we should require that disclosure to be repeated at a public meeting. The other standard is at the time the application is filed, which kind of goes to Commissioner Wood's point on the last one. So we are going to look at, we haven't made changes to this yet, but in light of the idea that the language proceeding has commenced is not entirely clear, we are planning on looking at those a little more carefully as far as the party disclosures. And again, I'll repeat, and possibly adding that agent disclosure that we talked about earlier as well to this.
Yep, Commissioner Wilson.
Mr. Lau, I think you probably answered this question, but I'm assuming in your extensive discussions and analysis and staff deliberations that you considered the scenario, particularly in a large city where you might have committee meetings on an issue before it comes before the full council. Is that be a correct assumption?
I mean, that is a possibility. I don't know that we haven't thought through disclosure as far as how that would apply in those circumstances, but that is a possibility we talk about.
Okay. All right, thank you.
All right. Any other questions for Mr. Lau? All right, please proceed.
Okay. Sorry, just writing a note for myself. All right, I think this is the last one. Regulation 18705. This regulation is in the Act's conflict of interest provisions and allows for the random selection of officials in order to establish a voting quorum if too many officials are disqualified from a decision. This is referred to as the legally required participation exception. The proposed revisions would clarify that this exception applies regardless of whether the disqualified officials are disqualified from the decisions under the Conflict of Interest Act or Section 84308. So that's proposed language. I mean, there's different ways of taking this one. Whether or not we need to extend this exception to this circumstance, and whether or not it is something for the commission to consider.
All right. Any questions for Mr. Lau on the legally required participation regulation? Commissioner.
No, I have a question for something earlier that before he leaves, but not this.
Okay. Any questions on legally required participation before we go back? All right, let's go back.
All right.
So on point 1, the statute doesn't define a candidate for elective office. It doesn't even refer to some other, it doesn't refer to the PRA or anything else. And I'm just wondering if we have a definition for that in our regs that we should cross-reference. Because, these committees persist over time, but not everyone has declared or filed with Secretary of State or whatever it is that triggers their actual candidacy. And so that just might be something we're thinking about, because you might be able to time your contributions in a way where they're not a candidate yet because they haven't declared or something like that. But maybe I'm missing some fundamental thing I'm supposed to know right now about when somebody becomes a candidate.
Okay, so as far as whether or not it might apply if there's grumblings that they might become might declare or but have not filed their official paperwork yet. Okay, we can look into that.
Good point. Any other questions for Mr. Lau? All right, thank you, Mr. Lau. Let's open it up to public comment. We are on item 5, pre-notice discussion of the regulations implementing SB 1439. Do we have any public comment?
Hi, can you hear me?
Yes, we can.
Hi, my name is Kira Kazanzas. I'm the CEO of Silicon Valley Council of Nonprofits, which is an alliance of 180 plus community-based organizations working to support thriving and equitable communities in Santa Clara County. Thank you for the opportunity to provide this public comment. So we are very concerned about the negative effects that Senate Bill 1439 might have on the ability of community-based nonprofits to provide critical human and other services in partnership with county, city, and other local governmental entities. At this point, we feel that the current language and how it's being interpreted by the commission and some local governments is poised to disrupt local government contracting and the ability of the board of various governmental entities to approve nonprofit contracts and grants, and will have a chilling effect on the personal First Amendment rights of nonprofit employees and board members. And let me just outline a couple of specific concerns. One is we do appreciate the clarification of who's an agent for purpose of the act. That clarifies that only those who directly advocate for or otherwise publicly support a permit, entitlement for use, or contract. However, the lack of clarity about which nonprofit employees have a financial interest in the permit, entitlement for use, or contract really threatens to swallow that clarification. It feels like any nonprofit employee could be interpreted to have a financial interest. We think, legally speaking, that nonprofit employees do not have a financial interest in individual contracts or funding sources simply by way of their employment, and would like that to be clarified. Obviously, yes, they have an indirect benefit from their employer's healthy funding, but not a specific interest in a specific contract. Board members of nonprofits also do not have an individual financial interest in a nonprofit funding sources simply by nature of their board membership. And nonprofits themselves, unlike for-profit businesses, do not make donations to candidates for public office. So it really would be specific agents who are making donations on a personal basis. Also, I think this lack of clarity about which nonprofit employees, if any, have a financial interest in a permit, entitlement for use, or contract will cause possibly insurmountable tracking problems, confusion, and unnecessary recusals of local governmental electeds. Thanks for trying to address these concerns in your regulatory capacity. Appreciate it.
All right, thank you. Appreciate your comments. Additional public comment. We are on item number 5. Is there any additional public comment on item 5?
Hello? Hello?
Hello?
Yes. Hi. Can you hear me?
Yes.
Yes. Hi. My name is Sean McMorris. I'm with California Common Cause. We did submit a letter last night outlining some recommendations and some concerns. So hopefully you'll get a chance to look at that. We do want to thank the Commission and their staff for working so hard on this matter. One thing in particular that we wanted to point out with respect to Regulation 18438.2 is that we strongly believe that the intent and purpose of the law is to prohibit contributions over 250 from applicable parties and their agents while a matter is pending before an agency or jurisdiction, not just 12 months prior to a vote of a governing body within an agency or jurisdiction. We read the law to mean that there shall be a minimum 12-month look back before a vote. For example, when many applications won't take 12 months to get through an agency, but that giving and receiving of contributions over 250 is prohibited for the entire period a matter is unfinalized in a jurisdiction. If a matter takes more than 12 months to receive all approvals, as many large development projects do, we believe it is counter to the intent and purpose of the Levine Act not to interpret the law this way, as it allows big dollar special interests to game the law by strategically giving hefty contributions to officers 12 months prior to a vote. And it also allows the officers who receive prohibited contributions to delay a hearing on a matter until 12 months have passed from the time they receive the prohibited contribution. We also have concerns that Regulation 18438.6 releases an officer or party from liability if an officer or party or their agents does not personally request a contribution from a party, either orally or in writing. If the law is interpreted this way, it would grant easy circumvention of the Levine Act, since anyone can contribute unsolicited to a candidate's campaign, for example, online. We also believe that the regulation should attempt to define when an officer has actual knowledge of a contribution in order to prevent a hard to disprove ignorance defense, such a defense is not allowed for other violations in the Political Reform Act and should not be allowed here. For example, if a candidate does not accrue all of the contributions from a person or party in their campaign finance reports, they're not allowed to say, well, I just didn't know that other contribution was from the same party, therefore I didn't accrue it, I'm off the hook. So I think there has to be some standard and some onus on the officer to do their due diligence here, which you were discussing, and I appreciate that. And finally, we believe the regulation should define when a proceeding is commenced and clarify the difference between pending and commenced, and do so in a manner that is consistent with the intent and purpose of the law to prohibit all contributions over 250 from interested parties to officers of an agency while a matter is pending before an agency, not just pending before an officer. Those are all my comments, and I appreciate all your hard work and consideration. Thank you.
All right. Thank you. Appreciate your comments. Do we have any additional public comment on item 5?
Yes, hello. Can you hear me?
Yes, we can.
Good morning, Chair, Commissioners. My name is Hank Heckel. I'm the Legal Compliance Officer in the Office of San Francisco Mayor London Breed. First, I would like to commend the staff for their thorough and very helpful work in preparing the draft regulations regarding SB 1439. As discussed here today, this is an important expansion of the Political Reform Act and provides strong new protections against actual and perceived pay-to-play corruption. However, along with it come significant questions regarding implementation and challenges for agencies and officials to ensure compliance. The regulations go a long way toward addressing these issues. In particular, I strongly encourage adoption of the changes to Regulation 18705, applying the legally required participation exception from the Financial Conflict of Interest Code to make that apply to SB 1439. That exception has protected officials, particularly executive officials, from disqualification where their participation in a government decision is legally required. the California Supreme Court laid out the importance of that exception to financial conflicts of interest in the Brown and Feinstein cases, where executives legally mandated and non-delegable duties must be recognized. It makes perfect sense to also apply that here in the context of potential disqualification based on campaign contributions. I would encourage the commission to also consider the interaction between the curing provision of 84308 D1 and the legally required participation exception. In other words, does an officer need to first exhaust the option of returning the contribution within 30 days from the time the officer knows or should have known about the contribution, and proceeding before relying on the legally required exception? Does the 30 days have to lapse before you can avail yourself of the legally required participation exception, or are these two available avenues to avoid disqualification? Finally, the ordinance does raise some questions that have been discussed about how agencies and officials are expected to know when a party or participant made a previous contribution to the official in order to vet compliance. The requirement in Section 84308E1 that parties and participants disclose that they made a contribution on the record is somewhat helpful in this regard. But I would encourage the commission and staff to issue further regulations or at least guidance to agency boards and commissions on how to effectuate this disclosure requirement. Perhaps boards and commissions should be directed to promulgate standardized notice forms whereby the parties can make these disclosures on the record regarding whether they made a contribution. This would help to clarify how and when actual or constructive knowledge is established for an official receiving the contribution. I think that one challenge here is that officials really cannot realistically in practice be expected to be perfect in checking with their campaigns and committees to check the contribution reports on a rolling basis for incoming contributions against listed parties to imminent proceedings. I would submit that's a fairly onerous burden because it would require constant checking as the list of contributions would change day to day as contributions come in real time. And so I would respectfully distinguish this from the financial investment conflict context, because an official would have control over their financial investments. They decide what they invest in, and so they can post a list and sort of make that available and have knowledge of what their financial holdings are, as opposed to campaign contributions over which you don't have control. They just kind of roll in when they come in. So I would just encourage the commission to consider that question. And I do think the actual knowledge standard in Regulation 18438.7E is really the right standard that requires actual knowledge, which could be based on the disclosure by the parties that they made a contribution, or just the fact that the official sort of remembers and knows that they received a contribution, as opposed to requiring this consistent checking of campaign reports. And the best way to air these potential conflicts is really to assist agencies in making these contribution disclosures by parties standard and consistent through some kind of form notice requirement. So I would really encourage the staff to take a look at that. Thank you for your time.
All right, thank you. Appreciate your comments. Any further public comment on item 5? All right, hearing no further public comment, I did want to follow up the first comment about nonprofits. How, under the existing draft regulations that we have, how are we differentiating nonprofit employees for purposes of financial interests? Like, where's the dividing line today under the draft regs?
I don't know. I think there's work to be done here on I mean, I just don't know where does that go to the board? Does it go to the people controlling the nonprofit? Direct, I don't know. I think it's something we will be going into and looking into more.
Okay, yeah, I appreciate that. I think that a complicated area, because it's gonna depend on the type of matter
Yeah.
at issue, I think, who you sort of pierce down to within the structure of the nonprofit, I would think. Mr.
Yeah,
Cambridge?
to a certain point, on that point, whether someone is considered a participant depends on whether they have a financial interest, and they cross-reference what a financial interest is for purposes of conflict of interest. So we're a little bit constrained by how that term is already defined in the conflict of interest context. So we'll look and see if there's some room, understand their concerns to address them, but then we're also butting up against what is considered a financial interest under existing law.
I appreciate that. Other commissioner comments, questions? Commissioner
Well, this is more of a question. I don't know if Mr. Lau or Mr. Bainbridge could answer, this question, or our executive director. What would be the process in the past when it comes to forms being generated for governmental bodies? Is that usually handled by the governing body, or do we make recommendations on forms that should be adhered to by local elected officials?
It's not routine, but we do provide model forms sometimes that aren't necessarily even required to be used. It's just here's something that will assist you in providing everything that we are asking. And so we have in the past provided model forms.
Thanks.
Yeah, I was going to say, I think the commenter, I appreciate it because I think he used the term we should mandate certain forms of boilerplate disclosure, et cetera. And I don't read that we have that level of authority under the law, but certainly we could do fact sheets and best practices and things like that and encourage people to use our forms, right?
Correct.
Okay.
I just also want to say that, anyone who goes to our website, once again, the staff does an excellent job in terms of putting up fact sheets, providing information. So, anyone who's at the local government level, if you go to our website, we always have a lot of information there that's always very helpful. So thank you.
All right. Any additional, Commissioner Baker?
Thank you. I thought I appreciated all the public comment. I want to reiterate, thank you so much for grappling through this. I know it is complex, and we're grateful for your expertise in working through it. I thought one of the points that was well taken was whether to exhaust the cure provision before the legally required part comes in. And so I know you're going to take into consideration all those, but that certainly was a very good comment to raise. And this is just feedback for when you next see us and as you work through it. The requirement that people who are coming to public comment disclose what contributions they've made. I know we talked about how transparency can have the opposite effect of what we want, which, a little bit cynical that an elected official might listen a little more carefully. But on the other hand, it could also squelch someone who is concerned about a housing development coming to their community, and now they've got to wonder, gee, I just read this form. I need to know, is my spouse ever given money? Maybe my employer's ever given money. I'm just here because there's something that's going to affect my town, and I want to make a comment, and now I can't. Is that what we are are we contemplating rules that affect that type of disclosure?
A participant does not have disclosure requirements. Okay. The parties do. The person applying for the permit, the license, or that might receive an entitlement are the ones that have a disclosure obligations under the statute.
Thank you. So when we're talking about potentially best practices and forms and here's what to disclose, it is a very specific set of people it's required of, not an interested public member coming up and saying something during public comment.
Correct.
For example. Okay. I wanted to make that clear because I was not clear on that after our discussion for the last hour. And the only one is I'm really going to be thinking about Commissioner Wood's good question and what the comments have added, which is, including from Mayor Breed's office, how much should an official fairly be assumed to remember about each contribution and the amounts? And I am very mindful of different names that don't necessarily that maybe aren't even used in more public parlance, but they're the name that is the contribution. for example. We just be mindful of that. In some cultures, a different name is used in everyday usage, but something for legal purposes of what's been a campaign contribution is what's given to the official. And we need to be mindful of that very specific scenario, but that does happen as we are looking at what knowledge is the official supposed to have about their contributions. Does that make sense? Yeah. Oh, thank you. Oh, I did have one more. It has to go to, you mentioned at the very beginning an hour ago, all the outreach that you've done. Has that included to, I've been thinking of some other organizations that represent elected officials that this could grab, like school board members, water agencies. Have they also had that proactive outreach that, of course, you've already done with CSAC and League of Cities? And if not, is that something that you might add to your list of things to do? I'm sure they're on top of this, but a school board member, for example, might have a whole nother layer of complexity that we haven't thought of. We're so focused on supervisors and city council members. So if that hasn't already happened, I encourage again, those water trade associations that represent elected officials, school board association is elected school board members. There's probably others I'm not thinking of. And I'm sure you have already tried to cast the net widely. Thanks.
Right. Any other questions, comments for Mr. Lau? Mr. Lau, any parting bits of wisdom or questions for the commission?
I think I'm good.
All right. Thank you again. Thank you to all of the staff who were part of this project. It's a heavy lift. It's a complicated thing. You guys are doing a good job.
Thank you.
Thank you. All right. Moving right along.
Chair, do you want to quickly talk about schedule going forward, just for the public's benefit and the rest of the commissioners?
Yes. So we will. We're going to take up this matter again at the March Law and Policy meeting, and we're going to hold an interested persons meeting in conjunction with the March LNP meeting. Correct?
Yeah, hopefully. My thought is, I'm kind of rethinking that, looking at the calendar and thinking about all the comments we have. So what we'll do is take what we have and get together another draft. And when we have that ready, maybe we can talk about the timing of that IP. We do want to have an interested persons meeting. We just want to make sure we have an updated draft and have it available to everybody so they have enough time to review it and absorb it before we encourage discussion. So if you don't mind, I would like to have a TBD on the IP. Once we have a draft ready, we'll then publish it and hopefully get better input that way.
Yes, I think that's reasonable, Mr. Cambridge.
Thank you.
Thanks. All right. That was. All right. Proceeding right along then. Moving to item 6, our legislative update with our senior FEPC legislative counsel, Ms. Nakano. Good morning.
Good morning, Mr. Chair, commissioners. Okay, there are currently 12 Political Reform Act related bills that have been introduced, 8 of which are new since the last commission meeting. I'll go over those in just a minute. The bill introduction deadline is tomorrow, the 17th. We have been making good progress on finding authors for the commission's legislative priorities this year. I've also reached out to the offices of the new vice chairs, both elections committees, regarding commission bills, and will continue efforts to get bipartisan support on commission bills as the session continues. I'll go down the list at the bottom of page 2 of the legislative update and give an update on where we are with all of the commission's legislative priorities. The first one relates to creating a centralized record of online campaign ads, also known as the Data Act. Assemblymember Lori Wilson will be authoring the Data Act this year. We do have a bill number. It's AB 868. Number 2 relates to adding disclaimers on committee-paid posts by third-party influencers. We're calling those influencers in quotes. Great news on this one. Senator Umberg will author this bill. He has been very active in disclaimers, the area of advertisement disclaimers, so I think it's a good fit. No bill number yet, but I'll keep the commission updated. Number 3 relates to disclosure of lobbying of local redistricting commissions. I do have interest on this one, but no commitments yet. Number 4 relates to authorizing file by proxy for the upcoming Cal Access replacement system. As I reported at the Law and Policy Committee meeting last week, I've been working with our legal division on further analysis of this proposal relating to any potential impacts to liability if this was passed. The The legal division conducted their own research and also reached out to the District Attorneys Association. And our conclusion is that allowing filing by proxy would create difficulties for prosecution. In particular, the district attorneys responded that this would create challenges for proving a candidate saw a statement before it was filed, making it difficult to prove a perjury charge. Number 5 relates to requiring redaction of private financial information on campaign statements. We have a very interested author on this one, but I don't have permission from the member's office to share more information yet. Number 6 relates to a contributor education and certification requirement. This one, unfortunately, I have not gotten much interest on, but I am continuing ways to explore ways to find a bill vehicle. Number 7 relates to creating a long-arm statute for the commission. I have also not received any significant interest here. Number 8 would require mandatory electronic filing for statements of economic interest for certain officials. I'm pleased to report that Assemblymember Avelino Valencia has agreed to author this proposal. And last, on minor changes / cleanup bill, it does appear we have at least one vehicle for this, so we should see most of these changes in a bill this year. I will have more solid information about the Commission's legislative priorities in the next couple weeks, and I look forward to giving that update next month. Okay, before I move on to other Commission-related bills, I'll pause here for any questions.
Commissioner Wilson?
Thank you for your presentation. Just a quick question about mandatory electronic filing. Would there be any exceptions for someone who, was not able to file electronically because of, a disability, or they're not really computer literate? I mean, is there any, exceptions in those rare instances where someone, would not be able to file electronically?
I don't think we have any written to the language at the moment. For folks who do file electronically, I'm not sure how we handle, for example, if they had a technical difficulty. I think we make exceptions and allowances in those kinds of cases. But there's currently not language that would create an exception for individuals in those cases.
Any other questions for Ms. Nakano? All right, please proceed.
Okay, moving on to other commission-related bills. Aside from the reintroduction of the Data Act that I mentioned earlier, there are 7 new commission-related bills that were introduced since the last meeting. 4 of the new bills are included in the written report, and the last 3 were introduced after the date of the report, so I will describe those verbally today. First, we've got AB 319 by Assemblymember Connolly. This one's not within the Political Reform Act. However, it imposes a specific requirement for the Department of Housing and Community Development's Conflict of Interest Code. And by amending the Conflict of Interest Code requirements imposed under the Act, it amends the PRA by reference. The bill would require certain investigators with that department to be designated employees for purposes of the department's Conflict of Interest Code, and would require those inspectors to disclose all interests in real property. The bill would also impose various other related duties on that department. I'm in contact with the author's office, and it's possible that we might see future amendments to take this bill out of the Commission's jurisdiction. AB 334 by Assemblymember Rubio relates to Section 1090, which generally prohibits government employees from being financially interested in contracts that they participate in making. The bill would provide clarification on when an independent contractor is not an officer for purposes of Section 1090. More specifically, the bill would clarify the circumstances under which an independent contractor who is hired for one stage of a government project could also be hired on for a later phase of the same project without violating Section 1090. SB 248 by Senator Newman would require a candidate for elective office to file a new disclosure statement with the Secretary of State's office under penalty of perjury that includes prior education and work history and history of military service. The bill states that in addition to being subject to penalties under the Act, a violation of these provisions would also be grounds for removal from office by a governing body with the power to remove an elected officer from office. At the Law and Policy Committee meeting, questions were raised by the committee about whether any particular intent standard would apply, what kinds of statements would be considered to violate the bill. For example, whether positive spin or embellishment of one's education or work history would be considered a violation. Unfortunately, I do not have those answers yet. I did reach out to the author's office and will be meeting with them next week, but I will update the commission on what I find out. Fourth is SB 251, also by Senator Newman. The bill would prohibit an elected officer from being employed by any other elected officer with the same constituency. Elected officers under the bill share a constituency if any individual is represented by both officers. The bill exempts from the term elected officer a person holding statewide elective office, which is defined in the Act. The Law and Policy Committee asked about how this bill differs from current law on incompatible offices. Current law on incompatible offices is in Section 1099 of the Government Code and out of the FPPC's jurisdiction. I'll also highlight 3 additional differences between that section and SB 251. First, Section 1099 of the Government Code applies to a person who holds 2 appointed or elected positions. SB 251, by contrast, applies to an elected officer who is also employed by another elected officer. Second, Section 1099 prohibits holding 2 offices when any of 3 circumstances is present. Either of the offices may audit, overrule, remove members of, or dismiss employees of, or exercise supervisory powers over the other office or body. So essentially, one office has power over the other office. Second, based on the powers and jurisdiction of the offices, there is a possibility of a significant clash of duties or loyalties between the offices. And third, public policy considerations make it improper for one person to hold both offices. SB 251, by contrast, imposes a blanket prohibition on being employed by another officer with the same constituency. So there's no similar opportunity for a case-by-case analysis or more nuanced factors. Third, the consequence for violating Section 1099 by holding an incompatible office is that the person is deemed to have forfeited the first office upon acceding to the second. SB 251 does not list any particular penalties or consequences for a violation. Because it's silent here and because it's within the PRA, the default penalties of the Act would apply. There's also other existing law prohibiting local agency officers and state officers or employees generally from engaging in employment activities or other enterprises that are incompatible with their duties or the function of their agency. Generally, this existing law leaves the determinations of what kinds of activities are incompatible and what the disciplinary action should be for a violation up to individual agencies. The Law and Policy Committee also had questions here about whether the bill would apply to an officer who held both positions prior to the effective date of the bill. There are also questions about whether this could apply to a volunteer or someone who just receives a stipend as opposed to a regular paid employee. Again, here I don't have those answers yet, but I will keep the commission updated. Okay, 3 more. Moving on to number 5, this is SB 328 by Senator Dodd, and these last 3 are not in the written report, so I'll just be providing a verbal update. The bill would impose the PRA's contribution limits on candidates for school districts, community college districts, and other special districts, or would require those districts to pass their own contribution limits. This bill is structured to be very similar to AB 571 from 2019, which imposed contribution limits on candidates for city or county elective office. Number 6 is SB 379 by Senator Umberg. This is an easy one, just a spot bill at this point. And last is number 7 by Senator Newman. It's SB 409, relating to candidate statements in the state ballot pamphlet. For a little background, this chapter in the PRA on ballot pamphlets was added as part of the original Prop 9 in 1974. It requires the Secretary of State to prepare the ballot pamphlet and lists its required contents, format, and related requirements. So although these requirements are in the PRA, this area is really under the responsibility of the Secretary of State. The bill requires the Secretary of State's procedures for candidate ballot statements to require that statements of candidates for statewide elective office be physically written by the candidate in a place designated by the Secretary of State. The bill would also amend the Elections Code to require state and county candidate ballot statements to be physically written by the candidate in the county elections office. The bill would require the bill would also require the Secretary of State to establish a pilot program in up to 4 counties to allow a candidate to additionally include in their candidate statement a QR code that links to a video statement. And that concludes my update. Happy to answer any questions.
Thank you, Mr. Kano.
No, go ahead.
One question, going back to AB 37, this is the expanding the use of campaign funds for security systems and personal security. I had one question for you. I note that under existing law, there is an obligation to reimburse the campaign fund for cost for the equipment upon sale of the property. Is that same reimbursement required under AB 37?
No, they struck the existing law and its contents were replaced by what is included in the legislation report, so that a similar requirement would no longer exist.
Okay. Right. All right. That was I just wanted to ask that question. Any other questions for Mr. Kano?
Yeah, just a quick question regarding, I think it was SB 251 regarding incompatible offices. I didn't have the opportunity to hear the Law and Public Policy Committee meeting, so perhaps the chair, Commissioner Baker, or yourself could shed some light on why isn't this already covered by incompatible office provisions that are currently in place? Was there a particular situation that prompted this legislation, if you're aware of anything you can share?
Very good questions. I haven't had conversations with the author's office on the impetus for the bill yet, but hopefully I'll have an update next month. Regarding how it's different from the current law, I think it's broader. There aren't particular factors as to whether there are specific conflicts. Rather, if you're an elected officer and you are employed by another elected officer and have any shared constituency, it's not allowed. So it's a broader prohibition than what I think current law requires.
All right, thank you.
On that same bill, I think when you're talking to the author, I think I mentioned this in Law and Policy, but I want to repeat it. You mentioned that the remedy, actually, it's not removing like under incompatible offices. It's a violation of the act, so it's a fine. But it's just not clear, is it a one-time fine? Is it a fine every month if they stay employed? Is it a fine every day? If this bill proceeds, we need much more clarity from the legislature on what our obligation is in terms of enforcing this if it passes.
Thank you.
Thank you, Commissioner Wilson, for that question, because we had nothing but questions in law and policy. And, it's early stage of legislation. I'm certainly, what's the back, if there's a particular scenario that the senator is trying to get behind that is not already captured in current law, I think that's one of the questions that we had asked. And the one that I had inquired about is both if a sitting council member volunteers in an assembly member's office, or that city, maybe they don't volunteer and they get only a stipend, or they get a salary, but the city council that they're on, they get per diem. And that's, are they trying to anticipate scenarios where there's salaries is a real issue that the senator's getting after? But we'll look forward to hearing more as this one goes forward. I had a question about I think it's a newer one as well by Mr. Newman, SB 248. That's the one requiring disclosure of the candidate's education, work, and military history. I think I said law and policy, gripped right from the headlines, of course. But you mentioned in your last paragraph, in addition to other penalties under the PRA, do you happen to remember what would be the penalties? Are they just per violation, $5,000 is the maximum? Okay, so our traditional penalty structure is currently in there. Okay. I think I had one more, but the chair might have asked it. Bear with me. I think that was the question. I mean, some of these we're just going to see where they're going to go. And the questions and feedback that we can have, we're not on the brink of supporting legislation or sponsoring it, but we have lots of questions about the two newer Newman-related bills. Candidate statements. That's right. That's the one I was looking for. That when you say physically, does that mean the candidate in person has to come in and submit the candidate's ballot statement, as opposed to it's been printed and they hand it over? That's what you mean by physically? That's the requirement in the Newman bill? The new one?
Yes, the language is physically written by the candidate in a place designated by the Secretary of State's office.
Writing it like in person,
I think
right there.
right.
Okay. I would be curious where the senator might be going on that one. It's like, what's the what's the issue that I'm sure he's hoping to fix. And on the QR code, of course, in a candidate statement right now, a candidate statement can say, and here's my website that you can go visit and see all kinds of things. It takes up your 200 or 250 words, I can't remember. But how the current rule of what you can put in your candidate statement doesn't already cover essentially what the senator is interested in. I mean, it sounds like he wants to have a QR code in particular, but you can already put your website. So maybe I would hate to see that as something that leads to potential work for us or violations or otherwise down the road. Thank you.
Well, I think on that point, didn't you start off your presentation by saying that's actually a portion of the act that's administered by SOS and the counties. So that, I think it's important to remember that that's not part of our obligation under the act. Is that correct?
It would be the Secretary of State's duty to establish that the pilot program for the QR codes. So they would be responsible for determining parameters and the specifics of that.
So it could, I wrote that one down, is that the SOS is responsible. But does that mean further down the road, if something goes wrong, if somebody doesn't do something that the SOS says Secretary of State has to do, that it's a violation that we have to deal with?
I
don't
think
know.
That's a possibility,
okay.
But we can think more on
All
that
right.
one.
That's what I was.
Yeah, if you could find out a more concrete answer to that question, I think that's important. I understood it to be more like ballot designations, which is a portion, right? It's if SOS doesn't like your ballot designation, they reject them. They don't, and if they're wrong, you don't get fined by the FPPC. You just don't get your ballot designation. But I think it's an important point to clarify, so we know what our obligations are. Any other questions, comments for Ms. Takano on her legislative update? All right, any public comment on item 6? Hearing and seeing none. Thank you, Ms. Nakano. We'll look forward to your presentation next month.
Thank you.
All right, we'll move then to our executive staff reports. Begin with our Enforcement Division report. Mr. Burton, welcome back.
Good morning again, Chair and Commissioners. I don't have anything in particular to highlight from this report today. I do, however, want to update the Commission just to let you know that we will be providing our next Enforcement Division update in April of this year to respond to some of the requests and comments that were made at the January meeting.
All right, thank you, Mr. Burton. Any questions or comments from Mr. Burton on his report? All right, thank you.
Thank you.
Appreciate it. All right, moving to Audits and Assistance Division, Chief Shaw. Good afternoon.
Good afternoon. My report is as submitted, but I can answer any questions.
All right, any questions for Chief Shaw on the Audits and Assistance Division? Commissioner Baker.
So you did report one of the audits that was done in quite detail, some of the violations found. So what happens, or findings noted, I should say. What happens next with a matter like that? Because we're kind of getting into the practice of the work that you do.
Yeah, so once we send out the audit report to the candidate and the treasurer and any other parties who are involved, the audit report is sent over to the Enforcement Division.
Okay.
And then the Enforcement Division reviews it, and if there is an investigation needed, they would proceed with that. Otherwise, they would close the case.
Okay.
It depends on the types of findings and the types of violations noted. So they will do their own reviews and then proceed.
Okay.
Needed.
Thank you.
All right. Can I say, sorry, just a logistical
Yeah.
question. So you refer it to enforcement, it goes to the Enforcement Intake Division to do to be treated just like a referral from an outside agency or a sworn or anonymous complaint.
Yes,
right?
that is our standard practice, to send all audit reports over to the investigation to Enforcement Division. Whether they have findings or not, we send over everything as part of our standard practice.
All right, thank you. Just wanted to clarify that.
All right, thank you.
Ms. Shaw,
Yes.
kind of as a follow-up to the Chair and Commissioner Baker's question, once it's referred to enforcement, approximately how long will it take before enforcement decides, okay, this is the case we're going to pursue, or it's not going to be a case that we pursue because it's already in the public domain by virtue of the audit. So I'm just kind of curious as it takes 2 months, 6 months?
It depends on the enforcement division's workload. However, there is a statute of limitations that needs to be taken into consideration. So once it's in their court, it depends on what their workload is and their process on how long it takes them to review, as long as it doesn't cross the statute of limitations.
This is not my decision, but I would think that because it is in the public domain, there'd be an interest in expediting it so that it's just not languishing out there for, a prolonged period of time.
If there are any serious violations noted, we would highlight that when we refer our reports over to them. So those cases do get expedited if needed.
Thank you.
Mr. Chair.
Yes.
So you just led right to what I was going to ask. So right here it says findings noted. In your last answer to my colleague here, you said serious violations noted. And so I'm wondering, is the word findings here important? Or would you only say findings and then you refer to enforcement and then enforcement decides whether it's a violation or not? Do you see what I'm saying?
Yes, in audit, we refer to everything as findings.
Okay, so you say findings and then they decide whether it's a violation. I gotcha. Okay, thank you very much.
Important point to clarify. All right. Thank you very much, Chief Shaw.
Thank you.
Appreciate it. All right, let's go ahead and proceed to the legal division. Mr. Bainbridge.
A couple of education items I just wanted to point out that are in the report. On February 28th, we're having a behested payment training webinar. It's a newer training. I think we've given it 2 times prior, but anyone who's listening that is interested, you can go to our website and sign up on our trainings page and be part of that webinar. And then the other item I'd point out is we put up a fact sheet on section 84308, the changes to the statute that are now in effect. It's pretty brief. It doesn't get into the esoteric issues we were discussing today, as those are still to be hammered out, but it gives some guidance on how the law works generally. So if those that are new to it, I would encourage them to check out our fact sheet on our website. And then the last thing I would mention as a matter of course is a regulation 18740 exception. This is for public officials who have a legal obligation not to disclose information that would otherwise be required on their SEI. And we have another consultant from CalPERS who obtained an exemption to not disclose certain clients of their law firm that are not otherwise publicly known already. And with that, I have nothing else to add.
All right. Thank you, Mr. Bainbridge. Question for you. It was just prompted by you talking about the fact sheet on 84308. As we saw today, there's a fair amount of engagement from stakeholders on that particular reg package. Do we have something on our website that directs people where they should be sending in written comments between meetings? Like, do we have a central staff person who's in charge of collecting that feedback between our meetings?
I'm trying to think.
Would that be helpful? I think that's the other question.
It is in some place, like when it's an agenda item, we encourage people on who they should reach out to, and when we publish the notice of the informed persons meeting, we'll have it on there. But I'll look at the website and see if there's a place that we could add that to encourage public comment. People can always send things to the commission assistant's email, and that will get filtered to the proper location, but we can give a more specific one as well.
Okay, just something to think about. I defer to you on whether it's helpful or not to do that.
It's really just finding a good location to put it, I think, would be what we got to figure out.
And the right person to receive them.
Well, I know who that is.
Right to Dave Bainbridge at FBPC.
Nope, that's not the right person. The right person's not here.
Yeah. All right. Any questions for Mr. Bainbridge on the legal division report? All right. Thank you, Mr. Bainbridge. And again, thank you to staff for their great work on the 84308 regs.
Thank you.
That was a lot of work. All right, moving right along, Administration and Technology. Chief Hahn, good afternoon.
Good afternoon, Commissioner and Chairs. I would like to submit my report this month as is, but I would like to update you from the prior month report that I submitted back in January. There was a typo that I erroneously missed a digit on item B for the statement of economic interest. There, instead of 15, there was 175 person who were required under the state and local agency conflict of Interest Code to file the 2021 and 2022 annual Form 700 report. I just wanted to point that out to you.
All right. Thank
Mr.
you.
Chair,
Yes.
can I just tell you that on that meeting, I was so impressed with you. I was like, there's only 15. California is amazing. She's doing such a great job. But I will note that 158 is lower than 175. So there's been good progress in this month.
Yes, my staff have made progress every single month after the filing deadline.
Great. Thank you. Thank you, Ms. Hahn.
Thank you.
And you will be reporting to us. Can you remind us? I know that this came up last meeting on the progress on the ADA implementation. Is that in March or is that in April?
Yes, my plan is to present the data to you guys in the March meeting.
All right, great. We look forward to that. Any questions for Ms. Hahn? All right, thank you very much. Executive Director West.
Good afternoon. So the only thing I wanted to report back is that we have published our annual report. It was sent to all the commissioners, posted on the website, posted on the agenda. It's also been sent over to the members of the legislature and to all staff. And it highlights all the good work that's been done by the commission in our prior year. And I encourage everyone to read it. I want to give a big thank you to Sasha Linker and Rieko Vesca. I was worried about messing up her last name. I messed up her first name. But so they did a lot of work on this. It's a big project to undertake. So I want to give a special thank you to them. And it's good reading, pretty pictures. So, yeah, take it with you on a plane.
Thank you, Executive Director West. Any questions for the Executive Director? Hearing and seeing none. Any public comment on item 7, our executive staff reports? Hearing and seeing none. Thank you. We'll proceed to our final item, commissioner comments, proposed future agenda items. Do any commissioners at this time wish to identify future topics of interest? Hearing and seeing none. We have reached the end of our agenda. Do I have a motion to adjourn?
So moved.
I'll second.
Ms. Linker.
Commissioner Baker.
Aye.
Commissioner Wilson.
Aye.
Commissioner Wood.
Aye.
Chair Manich.
Aye.
The motion passes.
All right. Thank you, everyone.
Mr. Bainbridge, what time of day is that webinar on the 28th?